Trước hết thì xin kính chào tất cả quý vị. Xin cảm ơn ban tổ chức đã tạo điều kiện cho chúng tôi được tham luận tại hội nghị quốc tế ngày hôm nay. Chủ đề tôi mang đến hội nghị đó là các quy định của pháp luật Việt Nam về trách nhiệm hình sự của pháp nhân thương mại và thủ tục xét xử pháp nhân thương mại phạm tội. Đây là một cái quy định mới trong cái bộ luật hình sự mới được sửa đổi năm 2017 của nước Cộng hòa xã hội chủ nghĩa Việt Nam, bổ sung chế định trách nhiệm hình sự của pháp nhân thương mại. Và đây là một cái điểm nổi bật mang tính đột phá trong chính sách hình sự của Việt Nam, làm thay đổi nhận thức truyền thống về vấn đề tội phạm và hình phạt. Việc bổ sung chế định trách nhiệm hình sự của pháp nhân vào bộ luật hình sự của Việt Nam xuất phát từ yêu cầu cấp bách của thực tiễn nhằm góp phần khắc phục những bất cập, hạn chế trong việc xử lý các vi phạm pháp luật của pháp nhân, đồng thời tạo điều kiện bảo vệ tốt hơn quyền lợi của người bị thiệt hại do vi phạm của pháp nhân gây ra. Về sự cần thiết quy định trách nhiệm hình sự đối với pháp nhân thương mại phạm tội thì trên cơ sở là thực tiễn trong những thời gian qua cho thấy là tình hình vi phạm pháp luật của các pháp nhân kinh tế diễn ra khá phổ biến và nhiều trường hợp gây hậu quả nghiêm trọng, nhất là trong lĩnh vực kinh tế và môi trường. Việc xử lý các hành vi vi phạm nêu trên của pháp nhân là các doanh nghiệp bằng chế tài về hành chính hoặc dân sự tỏ ra không hiệu quả, tính răn đe, phòng ngừa của các chế tài xử lý này không cao, hậu quả pháp lý của việc xử lý này đối với doanh nghiệp vi phạm chưa có số nặng đủ để phòng ngừa tái phạm, nên chưa đáp ứng được yêu cầu đấu tranh phòng chống hành vi vi phạm của các công ty và
commercial persons when committing a crime. In recent years, we have seen violations by commercial companies, and that is why we had to take more drastic actions to guarantee a strict compliance with the law and check the responsibility of companies that violate the law. One of the actions taken was to bring to trial those companies that violated the law. The management of a company is not only decided by its executive board. Sometimes decisions are taken by collective vote. So this is a case of collective violation of laws, because in these cases the role of the CEO is to fulfill collective decisions. So if the criminal responsibility will be for only one person, when other persons are benefiting from that decision, there will be a lack of justice. This is perceived more clearly in persons with foreign investment capital, in companies, in shareholder companies. The property of these companies are not the CEOs. Therefore, if we continue maintaining the criminal policy of only judging the CEOs, as it happens today, we will only be sanctioning individuals that are only managing a business or a company, and we will never bring to trial the owners of the company that are the main beneficiaries of these violations. the fact that the Criminal Code of 2015 establishes the responsibility of the company reflects the fact that for the first time we have this type of clause, and it reflects the current situation with companies and legal persons during this stage, particularly violations in trade, environment, money laundering, and financing of terrorism. To try these companies, and there is a rule to try or to judge companies. There are 4 requirements for a legal or commercial person to assume criminal responsibility. Crime committed on behalf of a legal person, crime committed for the benefit of a legal person, crimes that are committed under the responsibility of a person, and the code establishes the responsibility of legal persons and commercial persons, and the individual responsibility of the CEO and of the company. On the system of sanctions that are being imposed and against legal persons is defined in Article 3346 of the Penal Code, and includes 3 main sanctions: fine, suspension of activities, and permanent suspension of operations. 3 additional sanctions: prohibition of the business and of operations in certain sectors, prohibition of mobilizing capital, and 4 judicial measures.
Đó là các cái
The confiscation and seizure of property and money. Concerning the protection or the resources or arguments to determine sanctions and aggravating or attenuating circumstances for corporate bodies. On the aggravating and attenuating circumstances on criminal liability, Article 84 provides the circumstances to determine the exempting circumstances for corporate bodies. For example, we have managed to reduce or contain damages caused by the perpetrator. For their own will, they have rectified or have paid a compensation or indemnity for the damages or have contributed to repair its consequences. They committed a crime that did not brought about any damages, or the damages are not as significant. They've cooperated actively with the law enforcement bodies or during the solution of the case. Concerning the decision, in cases where the corporate body commits several crimes, the combination of several sentences and the exemption from sanction for corporate bodies. Our criminal code was modified in 2015. And there are provisions for trying corporate bodies in order to ensure that the Criminal Code of 2015 is appropriate and consistent, the Criminal Procedure Code of 2015 enriched or increased the number of provisions on the procedures and proceedings to try corporate bodies for criminal liabilities. Consequently, the Civil Criminal Code of 2015 rules the trying of defendants, modifying and supplementing it for corporate bodies, including the legal representative of the corporate body taking part in the proceedings. The punishments for corporate bodies, the issues to be defined when undertaking or filing actions against corporate bodies, the declarations of the legal representative of the corporate body, the temporary suspension of investigations, the dismissal of cases, the powers and procedures to try a corporate body, and in the preliminary hearings for corporate bodies, we must first determine whether there was an actual commission of a crime, the place and other facts of the crime. We need to determine the responsibility or liability of the corporate body, of its member, the aggravating or attenuating or ameliorating circumstances, accepting circumstances, to exempt them from sanctions, the nature and scope of the damages caused by the crime committed by the corporate body, and finally, the causes and consequences of the crime. The judge presiding over the trial decides to return the files to the prosecutor's office for supplementary research or investigation in the following cases: when there is a lack of evidence used to prove one of the articles or elements mentioned in Article 85 of the Criminal Code that cannot be added during the hearing. There are reasons to believe that, aside from the actions by the prosecutor, the defendant has committed other crimes that are defined in the Criminal Code as the following. There are motives or reasons to believe that there are other accessories to the crime or other individuals who have committed crimes related to this specific case but haven't been tried nor indicted. And however, there are files and the cases have been arraigned and there's been a previous investigation and claims by several violations or serious violations of the due procedure. There are other types of procedures to solve litigations during trial. Before the interrogation, the prosecutor reads the charges and presents the additional decisions or views, if there are any. The additional comments should not worsen the situation of the defendant. After that, the jury will proceed to the interrogation in order to determine all the facts of the crime and everything related to the individuals involved. In the cases of appeals and appeal trials, we must say that the punishments to corporate bodies is something rather new in Vietnam, and that has been introduced in the new criminal code in order to meet the current situation of the country in accordance with the Vietnamese legislation. Well, this is my presentation. However, I gave my presentation to the organizing committee, and in case you're interested in more details, you can ask for